that right to someone else to come on your land, so you don't solely possess the land during that lease term. But you're also giving them the right to take game off of your property. And so that, because at common law, fructus naturalis, that's the landowner's property. It can be regulated by the state, but it's still our property. So we're basically granting that that exclusive right to do that. And a lease is a property right. So and it is for a term. It is terminable, but there's going to be notice periods and things like that, unless it says that it's immediately revocable, which is, I don't know anybody that would agree to that. But generally, leases are going to create a property right that the person can then enforce. That, nope, I have the right to be here until the end of whatever the turkey season, or till July 1, or whatever date is going to be fixed for the future. So, but today we're talking mostly more about leases, where we're in the scenario that we've been approached by someone who wants to hunt our land, and we'll grant them the exclusive right to do that for however long we're granting them to do that, or a hunt club. And that's not uncommon. And in my mind, it's preferable, I think, to have a hunt club there as the lessee, rather than a collection of single unaffiliated hunters. But as such, the lessee, the hunt club, the hunter, whatnot, they're stepping into my shoes as the landowner in terms of their right to be there for that particular purpose. So that's maybe a little bit of a nuance difference there. One, let's see, I may have gotten ahead of myself. Yeah, I'll go ahead and put this slide up here because I used to get this question a lot, and I'm sure some of y'all do. But in my mind, when someone has the right to farm your land, and those rights are created in one of two ways. As y'all know, most farm tenancies in North Carolina are verbal. We have not yet gotten to a place where the majority of land tenancy, I don't think, is under written agreement. And so, as such, the North Carolina General Statutes protects a farmer's right to be on the land during that growing season and harvest their crop without landowner interference. That's a right that's guaranteed under state statute to a farmer. It's been given verbal permission to come on the land. But the question is, does that also what other rights does that sort of thing include? Well, in my opinion, the right to come on land under the state statute as a farmer is limited to that, is limited to tending that ground that you're farming and walking away with your crop. Doesn't give you any other rights to harvest timber, to collect firewood, to collect pine straw, or to take wildlife. And so I would say that the two rights are very distinguishable. And for my students, I always, in law school, they would, I'm looking for more pencils. The professors teach us the first day of law school, that real property is a bundle of rights. And so, one of these rights is going to be the right to farm, but the right to hunt is going to be a distinct right. And when you're in a written lease with a farmer, this should be addressed, I think, because the question might pop up. I had a client who had a farm tenant, and they wanted to come hunt on the farm. They wanted to bring their friends out and come hunting. And I said, they was like, well, I have the right to the property. I have this lease that says I can come on the property. And I'm like, distinct things, but it wasn't in the lease. And so now I'm sure whenever I'm drafting up a template for a farm lease of farmland, that it's explicit, that does not include the right to take wild animals from the property. And also, it's an acknowledgement that right to allow someone else to come on and hunt the property is still held by the landowner and can be freely given at the landowner's discretion. It's really notice to the farmer that during hunting season there might be somebody there's going to just know that the land's also going to be open for hunting in case you see, a truck at the path or something like that. And so, but I'll show you some of that language here in just a bit. So going back up to the top here. So let's first start with landowner liability, because you're inviting somebody to be on your property, and as such, the question arises, well, what duty as a landowner would you owe that person if they got injured on your property? And so people always everyone always phrases the question to me, can I get sued if? And I'm like, let's take the if off there, and the answer is yes, because it's not if something happens and you can at all be tied to that, either as a landowner or an operator of a facility or a lessor of a facility, it's likely you're going to be named in any sort of lawsuit that happens against for the injury that's occurred. And so then the question, as the varying insurance policies sort this out, the lawyers hired by each of those insurance companies are going to be working to get you as the landowner pulled out of this case as fast as possible, because you shouldn't be there. And so there might be someone that's coming onto your property, but the question is, if they get hurt, yeah, you'll probably be named in the lawsuit. But then the question arises, well, what's your liability to that person as the landowner? So the basics of landowner liability in North Carolina, if it's somebody who's an invitee, somebody who has permission to be on your property, then you owe them a general duty of reasonable care to make known to them hazards that you know about, or hazards that are reasonably discoverable. And so what that means to me is that it won't be something of you buying a piece of land somewhere. Let's say you buy 100 acres of unmanaged land and unmanaged forest land in a particular county, and you haven't really been much around it. You haven't really walked it, you haven't gotten around it so much, but then you immediately lease it out for hunting, and you've given somebody permission to come on your land at that point, right? And so at that point, your liability rises to the reasonable requirement that you owe invitees on your property. And if you haven't been out there and looked at your property, found the old homestead, the old well that's near the homestead, whatever it happens to be around there, and done some sort of assessment of the danger, yeah, I would say that your liability, there could be attachment to you there at that point if somebody got hurt. I think there's a inherent duty in all land ownership to know your property and to know its features. If you're not going to allow anybody to come on your property or give anybody permission, then it's not as big a deal. But if you're going to, ever allow somebody to enter your property for whatever reason, you need to be aware of what's on the land, and before you're inviting people on, either make sure they know that, okay, don't go near the cabin. There's an uncapped well there, an old well. Don't go here. This is a no-go area, whatnot, because there's a sinkhole or something. So it's your duty to know. Now, great question. Thank you, Devonna. That's where I'm going next. If you're a trespasser, so what North Carolina has done, and they did this, it was 2000, it was in the aughts at some point. We used to have three categories of, at common law, you have three categories of people that are on your land. Those that you've invited, those that you've allowed, like they called them licensees, or those that are trespassing. Well, the North Carolina Supreme Court eliminated the licensee category. So you have two classes of people that are on your land. Those that are there with your actual or implied knowledge, and I'll talk about implied, or those that are trespassers. And Devonna, your question here, if someone trespasses is injured, what is the liability of the landowner? Well, North Carolina common law and statutory law says that you are not liable. Section 38B-2, the general rule. Now this was, again, it was common law. So the courts, going back centuries, had already decided this rule that if there's a trespasser, you don't owe them a duty of care if they get injured on your property. That's on them. They were the trespasser. But along the way, our state government, our General Assembly codified this, that into this: as a possessor of land, including an owner, lessee, or other occupant, does not owe a duty of care to a trespasser and is not subject to liability for any injury to a trespasser. So there you have that. There you have it right there. Now, there are two exceptions. One, you cannot do things that are going to either willfully be there to discourage trespassing, or wantonly, and equate wantonly with disregard for the harm caused by the step you take. That I certainly think it's it would probably be, a jury question if to discourage ATV trespassers, you just strung a wire across a path entrance, from tree to tree, or even from post to post, something that wasn't really visible at dusk. Because, if I'm the parent of a kid who's over 14 or somebody, I'll get to the attractive nuisance doctrine, but if I'm the representative of somebody or that person who's been injured, I'm going to make an argument that falls outside the norm to just put, you knew ATVs were accessing here. You knew that just a brown cable would not be visible at dusk. You were doing this to discourage ATV trespassing by sending a message. So the common law is not big on that. That becomes what's known as a spring gun trap. That's the old thing where somebody would, mount a gun, tie a string to the door. Whoever opens the door breaking into the house is going to get shot. You're like, people do that? I'm like, yeah, it actually happened in the news. I don't know where in the country, but it happened somewhere very recently. And I think it was the owner that got shot by his contraption. But we get taught that in law school, that the spring gun trap, the gun pointing towards the door, same type of thing. So in short, don't do anything to discourage trespassing by sending an injury message. If you're when you block your paths and do things like that, if you're not putting a gate up, put reflective tape on it, make it known, make it easy, because that's all evidence that you're not doing something like that. You're not putting something up there that could send, potentially injure somebody and send a message. The other exception, attractive nuisance doctrine. This one's a lot harder for families of children to prove, because you have to prove all of these elements. But rather than go through each of these, the point is it only applies to minors under 14 years of age, and the landowner has to have, I'll just throw that one out there, reason to know that children are going to be likely to trespass, that they're attracted to the cliffs on the property, that they're attracted to the cliffs on the property, that people jump off into the bend in the river where it's deep. They come to the fishing pond. They do, there's various things that they might want to do. And the reason, the reason being is because what you're doing is you're imputing a knowledge on the landowner there that, I was aware that children were coming on to my property. And so that raises sort of an issue about the concept of whether or not somebody's a trespasser. So as a general rule, and I'm going to get to signage and posting here in just a bit, but as a general rule, if there's an open pathway, now in North Carolina, the old common law doctrine is that you did not have to, guard every path opening. Well, that was 1908. It hasn't been overturned, but that's over 100 years ago. And so common law does change over time. But if you have reason to know that people are coming onto your property, or if it's just sort of generally accepted that people cross your property or use your road to get to something beyond and whatnot, that's essentially implied permission. If someone can prove that there was a worn path in here, there was always trash, there was no secret there were people coming in here, that could be implied knowledge that people are on your property, they become invitees at that point. And so then your duty of liability goes much higher. I have a question, and let's see. I'm going to talk about signage and posting here in just a sec, and I need to speed it up also a little bit. Just real quick, in terms of landowner liability, just know that North Carolina Chapter 38 has a general liability exemption, which you can give somebody permission to be on your property, and then they can fall into the category of a trespasser to whom you don't owe any duty, if that person you've invited on your property is not paying you any fee or not doing something for you of value. This is our recreational liability limitation statute under a public policy that we want people to access land for various reasons, not just our state-owned lands, our refuges, and our state parks, but we want landowners to make their land available for various things. But if it's free of charge and someone gets hurt, there's no question of whether you allowing them on and you being aware of what it was that injured them. So this, again, but again, if you're leasing your land for hunting, you're charging, and so that statute's not going to apply. Okay, we talked about that. So I guess while we're on this topic, and then I'll segue into the hunting lease, but I'll go ahead and jump here because of the question posted about signage. We've had it on the books for years and years about posting the no trespassing signage, and here's the nuanced distinction to make about trespassing and what that means in the law. So trespass is, while it's a crime, or in certain circumstances, it is also a civil tort, meaning that if somebody trespasses on your property and damages your property, and this is apparent, we have a statute on timber trespass when somebody comes on and cuts your timber. We're dealing here with pine straw, but for whatever reason, trespasses on your property and causes you damage, whether it's water damage, whatever it happens to be. If damage is caused, you have a civil claim against that person, that trespasser, to get compensated for the damage they've caused. Let's distinguish that from the crime of trespass. And the crime of trespass, at least in our setting today that we're talking about open rural land. We're not talking about somebody coming into your house, breaking and entering. Different criminal scenario. My understanding on our laws on criminal trespass in rural areas all revolves around the concept of posting. So what's required to give the Wildlife Resources Commission officer or the deputy sheriff or any other public official with general arrest authority to arrest somebody for trespassing on your land is that you have it posted. So I want to make that clear. You might have a civil claim against somebody who comes on your land and takes your wildlife trespassing or cuts down your trees trespassing. But if you want the sheriff, the deputy sheriff, to come out and haul them off, or Wildlife Resources Commission to come in and make an arrest and get rid of them, that crime doesn't happen unless the person is there and you had posted signage as required by the statute. So that's why we have no trespassing signs. And I broke this slide up into two, but the statute is very specific that that you post up these signs for signage, not less than 120 square inches, not more than 200 yards apart. That's been on the books for a long, long time. But unless you post the signage up, then the sheriff's deputy doesn't have arrest authority on your property to pull the trespasser off. That's my take on it. And as most of y'all know at this point, if you're a landowner, this statute was revised now almost 10 years ago to add the purple swatch, what I call the purple swatch on the trees, so that it's harder for people to yank the sign down and say, hey, I didn't see any signs. What are you talking about? It's harder to take the purple swatch off the tree. Well, the statute is very, very specific on how big that swatch has to be, 8 inches long. Does it say the width of it? No, it focuses more on the length, but at least 3 feet above the ground and 100 yards apart. So we have to have more of those markings. But again, the markings serve the same purpose as the signage. They create the crime in a sense. They create the jurisdiction of the gendarmerie, the sheriff, and the WRC officers to come out and make an arrest and pull somebody off your property. And so what it essentially does is make criminal intent on the person. It imputes criminal intent to the person who is trespassing. Now the penalties, not severe. It's class 2 misdemeanor, which is pretty low level, but nonetheless, it's still an ability. You're subject to arrest. Are you guaranteed to be prosecuted? No, because the landowner can come over later and say, oh, no, it's okay. I'm not going to press charges. I told them they could be there. But one of the big parts of this law that's new and is now really, really critical is that you have to have on your person permission, written permission signed by the landowner. And people ask questions, well, what if it's air property? What if it's owned by 5 people? I'm going to say you're going to be okay if it's if your permission is signed by just one record owner. But you have to have this on your person because think of the scenario: the WRC officer is out on patrol, sheriff's deputy is out on patrol. They're going to see your truck by the at the path at the entry to that to the woods. They may know the owner, they may know it's not their truck or whatnot, but they have the perfect right, authority, should I say, not right, but authority to stop and go ahead and enter the land and see who's there. And upon approaching you as the hunter, this is what they're going to want to see, that you have permission. Now, are they going to throw you in the clink because you don't have this on your person? Probably not. You probably know the officer anyways. But they are going to issue a warning, but you're going to have to. My argument would be that you need to leave at that point because you don't have permission to be on the property, and so that becomes very, very critical. And when we start talking about, as I will here in a minute, start talking about leasing to hunt clubs, you have to have 2 things. The statute is specific about this. The hunt club member must have their hunt club membership card, and they must have the written permission slip from the landowner to the hunt club. So what that's doing is it's telling the WRC officer that someone's on your land willfully. And the last thing I'll say about access and liability, I talk about this a lot in my class, but just as a general reminder that traditionally navigable waters, a navigable tributary, or say an upland, the headwaters that are still somewhat navigable by boat or canoe or skiff or whatnot, up on your land, that's public domain water. So all of us have the right to be on the surface of navigable water, and we have the right to anchor in the bed of that navigable water waterway, because both the water is public trust, it's owned by us, and the bed underneath the waterway is public trust. It's owned by all of us, so we have the right to anchor there. Now, does that mean a boat has a right to tie up to your tree? No. Or does someone have the right to exit the water and chase a goose or something that fell on your land? No. But as a landowner, you can't come to the edge of the stream if they've gotten up there by boat, purely by boat, and run them out. So let's talk about the leasing. Does anybody have any comments or questions? I appreciate the what I'm getting here in the chat box. Kimberly, great question. No, so the question Kimberly's asking is, there's recently been a drawdown of federal jurisdiction over waterways. We call them waters of the United States. And the concept of that, it's very tied up in traditional navigability of waterways. And so what essentially is happening is the federal government can no longer, on certain waterways, impose restrictions. And this is the federal government. The state government, and when we talk about navigable in fact and public use of water, that's a pure state common law question. It's unrelated to waters of the United States, but it is sort of in the similar ballpark of understanding about what's navigable and what's not. And so my son's about to make an appearance, by the way. What rules apply when a hunting dog coming on your land begins to cause damage to your livestock? Whoa, Joe, careful. That's a great question. If that's a trespass, that's an instrument of someone. That I would say is both. Excuse me, sorry, is both going to be a trespass by the person who owns that dog. If your land is posted, I would argue that becomes a criminal matter. But even if it's not posted, the trespass by the dog that causes damage to your livestock is going to be a civil tort. It's going to be a civil tort against the owner of that dog. Whether the dog is considered vicious, whether it's just a regular hunting dog, whatever it happens to be. But in answer to your question, Rebecca, yes, what it means is that while there's no statute that I'm aware of, and I hope I'm not wrong, but I'm not certain, but from a civil liability standpoint, if you're the landowner and you own livestock and a hunting dog has come and hurt some of that livestock, you have a civil claim against the person who owns the dog. I don't think there's a specific statute that imposes automatic liability on that. But trespass is an intentional tort. It's not based in negligence. So the fact that the dog's on your property, the dog, that's an intentional trespass. So great questions. So let's, we were talking about right to hunt. So let's talk about hunting leases. So as I mentioned, again, there's no verbal permission legally. There's only really written permission for somebody to be on your property and to have be free from arrest. But the only time somebody has a right to be on your property, in my view as a lawyer, is when they have a lease from the owner or a written document from the owner that's granting that right. And the way that's done is through a lease. It's essentially saying you have the right to access and be on my property for a certain amount of time. Well, as you can probably tell by now, if I had a client that was not interested in putting something in writing, I would be telling them, and by no means allow somebody just to, your friends and family just to access your land. I would want to have, I would want to be in control of that somehow. I'm going to break real quick. There's a good question. Can the landowner permission card be photographed and the picture be shown to the officer? I'm not sure. The statute's not specific on that, but I would say that would probably be that might work. I've often thought of that if I couldn't find my fishing license, I have a picture of it, whether, out on Oak Beach, the National Park Service would allow that. But I think that might be okay. I think it just depends on the officer. So with hunting leases, again, the hunting lease is going to be a written document that, I'm sorry, all the lights have gone on, that is going to be the agreement between you as the landowner and the hunter. And so I've put some issues on here that have that I'll address. And one, probably the easiest way is just to walk us through a template of a lease. I want to make a comment because I'm going to put a restriction in my lease making it a default if whatever the current season's hunting regulations are not followed. Even to the point that if a WRC officer, makes a citation of a club member or my hunting tenant, I might consider that grounds of default, and I can go ahead and terminate that lease if I want to. Would I? I don't know, but I mean, again, that's up to you as the landowner to make these types of decisions in agreement with whoever's going to be coming onto your property. But I throw this up about county firearms regulation because one of the issues to consider is the relative freedom that you're going to allow your hunter to have on your property, or the hunting club to have on your property. And what I mean by that is you've given them a lease, they're going to pay you for it, it's going to be a certain term. Well, what do they do once they get on your property for their hunting? One of the issues that I have that I think landowners should be careful with is restricting their ability to do sighting, weapon sighting on the property. Reason being, we get into a gray area there. The Court of Appeals has been pretty clear in at least 2 decisions that shooting ranges are not bona fide farms, are not exempt from zoning. Excuse me real quick. Okay. Please turn the line on. And sorry, everybody. Gather my thought. I wouldn't want a landowner to get into a situation where the neighbors are complaining because they're hearing, multiple rounds being discharged on a piece of property and thinking, hey, we didn't know that there was a shooting range going to go there, or they've set up a tactical range that's not allowed by zoning. And so I discourage landowners from giving carte blanche to hunting clubs or other hunters to go ahead and bulldoze up a berm or something so they can do their sighting on property. It's like, let the hunting club take care of that at a professional permitted range, but not use your property for that. And the only reason being is because even though you might be able to prove that it's not a public course, you're still going to have to deal with it. And one of the things we don't want to deal with is neighbor complaints and the county coming out and telling us or asking questions about what it is we're doing. So I throw that out there, that the counties have the right to regulate shooting ranges, and so to not fall into that trap by allowing that to be set up on your property. Counties can also, of course, prohibit hunting on Sundays. That's specific in the statute. But again, the lease that we're talking about generally is going to talk about using as a matter of default that if the hunter or club does not follow all the regulations, that's a default, and the lease can then be terminated. A couple of issues, and I'll get to the lease here and at the very end. Probably took this longer than we all needed. Be careful about coordinating your leasehold with any timber contracts you put out there to make sure that both parties know about that, but really to make it to where their timber cutter, which is going to have a window of time by the time to get out there, that it's not going to be done right in the middle of deer season or turkey season, because that's going to frustrate the purpose of the hunter's lease. Ensure that farmed areas on your property are clearly marked. So I'm going to show here in a minute an exhibit how I prefer to do these types of leases, to clearly mark things to show folks where the hunting areas are. I already talked about excluding hunting rights from farm leases, but mark your no-go zones, and I already talked about target practice. So I talked about this too. Just again, I would say generally not a good idea to allow somebody to set up a shooting range on your property to sight their weapons. And so because I was talking about that, this is what I'll put on exhibits. I thought I'd blacked it out of all identifying. Oh, here's what I wanted to show you. Here we go. took off all identifying information on this. So I've sort of blacked out the roads and whatnot. But just an example of what I might do on an aerial of a hunting lease to show the hunter what the sections are, to help coordinate where however it is that you're going to organize who can access what, when, and where, so you don't have two people going after the same deer stand, but also clearly marking no-go areas, places that you're not to shoot into or not to set up or hunt in, and then that's a big area there. But really just doing a visual demonstration of what I think every hunting lease should include, because you might also, if this is cropland or something like that, depending on the time of year, make that unavailable. Sorry for the disruptions, everybody. So anyways, I've pulled this up. So let's just walk through this real quick, and then certainly answer more questions. This is a very basic hunting lease. It's in favor of a hunting club. And I'm just doing this to sort of demonstrate that, the different levels that you'll go through if you're going to be leasing to a hunting club, because as a lawyer working with a client, my preference is to, if you're going to, market your land as available for hunting, is to have a hunting club and let them do the policing. Let their management structure do the policing of their rules and how they go about doing things. So you as the landowner are not in that situation, because who's a member, who's a guest, things like that. And so and in a way it gives you some input into what their specific rules might be for your tract of land. Who can actually go there and when, how many at one time, what type of coordinating system should the club set up, maybe even maintain a sign-in sheet at the path entrance or something like that. But I would prefer that be on the hunting club, and they're managing all of that. And so anyways, but this is a very basic hunting lease. The highlights of it, here I've made it exclusive that the hunting club is going to be the only hunting club that's going to be allowed out there. I'm generally saying where the property is, but of course I'm more specifically describing the property on Exhibit A, a visual representation. And so for this, I've identified a lease term, August, so they can get into some allow some preliminary prep, maybe some site ways, or go ahead and affixing some temporary stands to trees, things like that. But then ending this in July after all the hunting seasons, various hunting seasons have expired. Coming up with the lease payment, that's a matter of agreement. Excuse me, the leased area.
Andrew, hey, this is Kim. What we're seeing, or at least what I'm seeing on my screen, is just a picture of the map. Are you looking at something else that we're not able to see? Because it seems
I am. Thank you. Sorry, everybody. Can you all see what I'm looking at?
What we see now looks like a GIS map, and it says hunting lease exhibit.
That's okay. I see what's happening.
Okay, maybe that's.
Yeah, sorry, but let me fix my screen share real quick. I had it focused in on the PowerPoint.
Okay, there we go.
Okay, everybody.
I think that's what we need. Thank you.
Yeah, sorry, everybody. I was looking at my screen and going, no, I'm just moving things around on the screen. So I'll back up a little bit, but this is what I was talking about. Again, it's a basic hunting lease that I've set up with a hunting club. And again, as I showed you with the map, that's my visual representation of the various hunting areas on the property. And I'm also doing that because I'm trying to keep the hunting away from the farming. That particular map I showed shows a lot of grazing land, but what if we have row crop land that's in the open areas in between the woodlots on that particular tract? And so, in some measure, this is what I've mentioned verbally. Setting up a term, the lease payment, leased area. And so, and again, this was just this particular lease, but you can, the agreement that you have with your your hunter is your agreement. It's, you have the freedom and the right to come up with whatever agreement you want to. In this particular one, because in the fall there's going to be some harvesting of soybeans going to maybe be in the field or whatnot, and if that coincides with whichever season of deer, um, uh, we want to make sure that when the farmer's in the field, that that we know that the club knows that that's a going to be a no hunting time. Now that raises another issue about how you coordinate that, and I'm not really addressing that, but I think that's an issue that should be addressed. So in this here, I've said lease terms. I'll get to that, but this is the key part here: failure to comply. I'm just putting a basic. I'm just putting in fact, 4, 5, and 6 here, 5, 6, and 7. Excuse me. I'm basically putting a blanket reference to if you violate county ordinances on shooting and hunting on a particular day, if you violate your member rules, you don't enforce your member rules, or if you fall afoul of North Carolina game laws, or your members fall afoul of North Carolina game laws, the lease is subject to termination. So it's putting the risk on the club, on the hunter, to police their own show, to make sure that that one person screws up, it could screw it up for everybody. So I think that provides a strong incentive for them to do a good job of it. And my assumption is that that's what the clubs do, but you never know. something could happen. And I'm also requiring, particularly if it's a club, I'm requiring an insurance policy. So if somebody, I may have misidentified that paragraph, but if somebody gets hurt, I want them to have a policy that's going to pop up in place of anybody trying to come after me as the landowner for any sort of money, and test those theories of liability. As such, if that happens, if for some reason I'm found liable, I have an indemnity clause, which means that my bills are going to be paid by their insurance policy if that happens. This is all boilerplate here, but one paragraph that I do put in there is this assumption of the risk. Now, is this totally going to do away with my liability if for some reason there's a uncapped well that somebody falls into and I didn't bother to go see that it was there in the first place? I don't know. But at least I'm trying here in this lease, saying you're assuming the risk that there's going to be, that you're walking onto land and things happen on land that don't happen on a city street, or happen in the woods that don't happen on a city street. Some would argue it's safer, but this is basically trying to put it on them and deflate any claim of duty that you owe them for something that might happen on that particular land. And finally, even though there's some other boilerplate, I put on here too, just for kicks. You can come hunt the land, but I haven't been managing it as a feedlot as a feed plot for dove or anything like that. It's just my land. I'm not saying that I'm not guaranteeing you're going to take your limit of deer this season or turkey or whatever. It's being leased as is. So. And then the last thing I would note, so as exhibits, here's my property map, but as exhibits, I'm going to put a little bit more fine tuning in here. That's kind of the main agreement. I'm just adding like kind of the rules as as incorporating these terms into the lease itself. For here, I've said that I'm limiting it to rabbit, turkey, and deer. I also have the ability as the landowner, the right as the landowner, to limit the methods of take. I can, not allow my property to be leased for dogs, or for trapping, or for types of traps, or for things like that otherwise might be legal under game laws. I might not want to allow that, and so I might prohibit that. Again, I'm requiring valid hunting licenses. All of that One thing I'm also, it might be a good idea is, and I say and display on the vehicle, and I would think this would be a good practice for any hunter anyways, is to have a copy of your permission card and put it in your dashboard. So when the sheriff's deputy or wildlife resources control officer comes up, they can just look in the window and see on your dashboard, and it's sitting right there for them to see, and they won't come in and disrupt your hunt. I would imagine. So that's probably just a good idea tip for hunters. So question, where can somebody get a copy of this, the basic lease agreement? On my farm law site. After we finish this, I'm going to go ahead and post up this, this template. It's just a draft. I'm going to take the exhibit off of it, but again, it's just it's a draft that I really need to clean up. But I have a question, limitation on hunting methods. So the last that I'll show here is that I want to have the rules of the hunt club also part of the lease, because I want to incorporate the rules as such that if the hunt club is not enforcing its own rules, I want there to be a penalty to that. I want to provide encouragement that they're going to do that. And you see here, and this is just standard, but I've limited ATV traffic. Why? Because I don't want to if I hear an ATV back there with frequency, that might be a trespasser. And so, because it's perfectly possible that someone's going to come and trespass on your property during the hunting lease. It's not as if that people are just going to say, "Whoa, okay, it's occupied by hunters." But I'd prefer that ATVs not be back in there. Now, is that raising a disability and access issue to hunting? Certainly. That's a conversation that I'm having with the hunting club as the landowner. Here, I've said ride a bicycle. It's like, who rides a bicycle when they're hunting? I've limited here that ATVs can retrieve down game, but not be used just to kind of ride around and scout and just casually go to and from the deer stand. And I've also limited, I don't know if it's in the rules here, but I've allowed in the lease for temporary stands to be set up, but in no event have any nails or spikes driven into trees, whatnot. I don't want my timber lot to have potential hazards for the mill someday down the road. So I've gone an hour. I've gone over an hour. My apologies to everybody. I see Kim put up the farm law website. I'll post this sample hunting lease up there. Again, it's just a draft. It's a beta draft, but hopefully you can manipulate it how you need to do it. But I think it has all the critical elements. Here's my contact info, which I know you can't see, but there, that's me. But I really appreciate y'all, having me come and talk at you for an hour. So.
Andrew, we really do appreciate you being with us today. I speak for myself, as I learned a lot of information, and I'm sure everybody else did as well. We really appreciate it.
Thank you. Let's see. There's a question up there. Thank you for the information on access. Does this apply equally to those wanting to use our land to access navigable waters? So certainly, you are under no obligation as a landowner. There's no legal requirement that you allow somebody to cross your land to access an otherwise public trust waterway. That's the challenge. If you're a member of the public and you want to be on that water, you got to paddle upstream. You got to get up there on the water. You don't have any right to access upstream by crossing someone else's land. So that's pretty, that's it. At that point, when they're doing that, they're a trespasser.
if anybody else has any questions, go ahead and put them in the. Still got a little bit of time. Go ahead and put them in the chat box. Or we don't have a large group here today, so if you'd like, unmute yourself and
Yeah, mute and speak up. Just ask a question. And this is it's an evolving area for me in terms of I guess for y'all's knowledge, I mean, one reason I do pay a lot of attention to this from the university perspective on campus is that a lot of my students, particularly my environmental law class, are wildlife management majors over at the College of Natural Resources. I'm always excited to have them in the class, and some of them are moving on to a career in law enforcement and wildlife and game laws, and so I'm always really trying to learn more about the case law on the question that came up about dogs, hunting dogs getting loose and things like that. It's an ongoing study, so as time goes on, there'll be more information on this type of topic. But I appreciate your comments that y'all put up there.
Thank you, Andrew. It's a great presentation.
I appreciate that. And for those of y'all who saw me get discombobulated, that was my son Joe. He's special needs. He's not in school because no one is, and but he's obsessed about lights and when they're on and when they're off, and so he doesn't care who I'm talking to. He's just going to come in and turn the lights off, or sometimes even unplug the computer.
Any other questions for Andrew? All right. Appreciate everybody coming today.
Yeah, thank y'all. Thanks for coming.
Yeah. We have next week. What's next week's presentation?
So it looks like, Andrew, I don't know if you're still looking.
I am. I see Carol's question.
Yep. Thanks.
Yeah. What are the rules about hunting dogs running across your land? So as a blanket matter, no one has the right to come onto your land. Not to run their dogs across your land, not to chase game onto your land. I don't believe so. I'm pretty sure there's not that's not a thing. But in terms of the rules, I'm just going to call it the rules of trespass that I put out there earlier. I'm gonna say that's on the part of the owner of the dog if they are not in control of their animals. And again, if they're running a pack of 20 beagles, yes, dogs do get loose. They do get lost. But nonetheless, they are responsible for controlling their dog pack. It's not acceptable that if they're going to take the risk of releasing a dog pack to enter the woods here, that the area that those dogs are going to move through is all area that person has the permission or right to hunt. There's no real there's no real allowance for dogs to go off on other places. Michael, I appreciate that comment. That's an area that I'm iffy on is the right to do retrieval, but I'm going to zero in on that issue.
Johnny, what were you saying next week's topic is?
Next week's topic is coyote and vulture depredation issues. Jonathan Carrito from USDA Wildlife Service, APHIS, and Jonathan, I think, was with us earlier. I don't know if he's still on or not, but I'll look forward to hearing him talk next week about coyote and vulture depredation issues coming up next week. So thank you again for joining us this week, and hopefully next week you'll join us for Jonathan's talk.
All right, like you said, we're going to go ahead and end this. We hope to see y'all next week. And Andrew, once again, thank you, and we look forward to seeing y'all next week.
Thanks, Andrew. Great information. Good seeing you.
Very much appreciate being here.
Thank you.